Hey y'all, Bonnie Roden here, your favorite family law attorney, serving East Central Florida from Roden Law Group. If you're watching this, there's a really good chance you're going through one of the harder seasons of your life. Maybe you're in the middle of a divorce or a paternity case, or maybe things are already final and you're trying to figure out how to actually make co-parenting work day to day. Whatever brought you here, I want you to know that what I'm going to talk about today is practical. It's grounded in Florida law. It's grounded in what I see working and not working in actual families. And it's focused on the one thing that matters most in all of this, your children. So let's dive in. So what does Florida law actually require? Let's talk about shared parental responsibility. So the first thing you need to know is that Florida law presumes shared parental responsibility. That's in Florida Statute 61.13. What that means practically is that unless there is a specific finding by the court that shared parental responsibility or shared parental decision making would be harmful to the child, both parents are expected to retain full parental rights, full decision making, joint input on major decisions, healthcare, education, religious upbringing, even ear piercing. Some courts have found driver license privileges are joint decisions. Joint is the default. It's not something that one parent gets to take away from the other simply because they're angry or because they think they're the better parent. Shared parental responsibility is the point where Florida court starts. So equal time sharing is now the presumption. This is a big one. It changed in 2023. So as of July 1st, 2023, Florida law was amended to create what is called a rebuttable presumption in favor of equal time sharing. What does that mean? It means that when a court is writing a parenting plan or developing its order and making its decision, it now starts from the presumption that each parent should have approximately equal time with the child. If you want something different from that, if you're asking the court to give more time to one parent than the other, you have to show why equal time sharing is not in the child's best interest. The burden is on you to overcome that presumption. This is really significant. It reflects what research has been telling us for years, that children in most circumstances do better when they have meaningful, ongoing relationships with both of their parents. So how do we navigate this? So a parenting plan is the document that most parents need in Florida, or actually all parents need in Florida, whether it's a dissolution of marriage or if it's a paternity case. The parties are required to have an approved parenting plan. It can be a separate document or it can be combined with a marital settlement agreement for those people who are getting divorced. I prefer to have them as separate documents simply because a parenting plan can be handed out to a school or a club or a coach or a doctor's office, and then it doesn't have all your personal information from the divorce like debts, assets, alimony, etc. The parenting plan has to cover specific things. There are requirements. It has to address how the parents will handle day-to-day parenting responsibilities. It has to include a time-sharing schedule, not just a general idea of time-sharing, but an actual schedule including holidays, school breaks. It has to designate who is responsible for health care and school-related decisions. It has to address how the parents will communicate with each other and how the child will communicate with a non-time-sharing parent. Here's what I really need you to hear about this. A parenting plan is a court order. It is not a suggestion. It is not a starting point to negotiate with the other parent after the final judgment. If you violate it, there are consequences, contempt findings, enforcement orders, attorney's fee awards, and in serious cases, maybe a temporary modification to your timesharing. So once the parenting plan is determined to be your final parenting plan by court order, whether by agreement or after you go to trial, that's it. That's your instruction booklet. So what about the best interest standard? Everything in Florida family law involving children comes back to the best interest of the child standard. Florida Statute 61.13 lists all the factors that a court considers when making any decision about children and time sharing. It's in 61.13 and the list is from A to T. So that's a long list, a lot of factors. I'm not going to go through all 20 right now, but I'll highlight just a few that I think parents don't always realize that they matter. So one of those factors is the demonstrated capacity of each parent to facilitate and support a close parent-child relationship for the other parent. So the court is looking at whether you, that's you, are willing and able to support your child's relationship with the other parent. Another factor is which parent is more likely to honor the time-sharing schedule and be reasonable when the other parent makes a request that is not outrageous for a schedule change. The court is watching you and how you behave, both of you, and the parent who is blocking, obstructing, withholding. That is the parent that tends not to do well when the matter appears before a judge. All right, so that's the legal framework generally. Let's talk a little bit about what actually makes a difference for the children. Keep your kids out of the middle. I know you've heard this. I'm going to say it anyway because I see parents do this every single day, and they may even do it when they have the best of intentions. Keeping your kids out of the middle is not just about not bad-mouthing the other parent. That is part of it. But it's about not asking your child what's happening at the other parent's house. It's about not sending messages through your child. It's about not reacting, even visibly, even non-verbally, when your child comes home happy and talking about a great time that they had with the other parent. Your child loves both of their parents. Most do. That love for the other parent is not a threat to you. And when you treat it like one, even subtly, your child feels that. Children in those situations become like little diplomats. They learn to manage their parents' emotions, and they can do this at a very young age. They learn to hide things. They become secret keepers, and they carry that skill with them into their adulthood. The emotional labor that we're asking a child to carry when we put them in the middle is real, and it has real lifelong consequences. Keeping your communication like a business partner is a good thing. I tell clients this all the time. You are no longer in a personal relationship with the other parent. You're in a business relationship. The business is to raise your child to be a successful, functioning adult. And like any business, it requires functional communication, regardless of how you feel about the other person. Practically speaking, this is one of the reasons many Florida parenting plans now include a requirement to use a co-parenting communication platform like Our Family Wizard or Talking Parents. These platforms keep all of your communications in writing. They create a record. They provide a buffer that reduces the chance of emotionally reactive exchanges. And if the matter comes back to court for any reason, that record is printable and it can't be changed. So the court values copies of those communications through those applications. When you are communicating with your co-parent, keep it brief, keep it child focused, and keep it free of commentary about their personal life, their choices, their new partner, anything that is not directly relevant to the child. Leave it out if it's not relevant. A good rule of thumb, if you would be embarrassed for a judge to read it, don't send it. So, consistency is important. You got to pick your battles. Kids do better when things are consistent. Rules, routines, expectations. When those things are relatively consistent across both households, it creates stability for the child. This is especially true for the younger kids. Here's the reality. You cannot control what happens in the other parent's home. And attempting to control it through litigation, filing motions every time you disagree with the mother feeding pizza and Coke on Friday nights, or the father allowing the child to stay up an hour later on the weekends. Focus on what you can control. The filing of the motions every time you disagree, it's expensive, it's exhausting, and it's almost never effective unless the court can be shown there is a genuine safety concern. So feeding chocolate bars to a diabetic child, that would be a genuine safety concern for you to bring to the court if it can't be worked out first by the parents. Focus on what you can control. Your home, your routines, your relationship with your child, and let the other household be the other household unless something is actually unsafe. If you want to work together and you're capable of co-parenting together in order to keep the schedules the same or keep the pizza and Coke routine the same, you can certainly do that. Chores can be the same. Discipline can be the same if you and the other parent are capable of co-parenting in that way. At the end of the day, you want to show up together when you can. One of the most powerful things you can do for your child is to show up, both of you, both parents, for the things that matter to them. School conferences, pediatric appointments, recitals, games. Invite the co-parent to the birthday party and invite their significant other or new spouse if there is one. There is no reason that as adults you can't put forth a joint parenting presence. You don't have to sit together. You don't have to be friends. It's good if you are, but you don't have to be. But being present in the same space for your child sends a message that no therapist, no attorney, and no other person can replicate. Both of my parents are here for me. I don't have to choose. I understand this is not always possible, and in some situations it isn't safe. But when it is possible, it is worth the effort. All right, so my clients usually hear me talk about documenting. Document, document, document. You want to document, but you don't want to weaponize. If your co-parent is consistently failing to follow the parenting plan, missing exchanges, withholding the child, failing to communicate, not sending over medical information, just document it. Keep a calendar. Save your messages. Note the dates, the times, what happened, what didn't happen. Documentation protects you and it protects your child. And it is how you make your case if the matter needs to come in front of a judge. But, and this is important, documentation is not a substitute for trying to resolve things directly in good faith first. Use that parenting app. Use the features in those apps that will fix your grammar as well as fix your tone. Courts expect co-parents to make reasonable efforts to work things out before filing motions. A parent who runs right over to the courthouse over every minor issue or schedule hiccup rarely impresses a judge. And they do remember, document, yes, but also attempt resolution, um, even while you're documenting. Get support and don't wait for a crisis, please. Divorce and separation are hard. Paternity actions fall into those same categories. There is no version of family court that is easy. Seeking support, whether it's individual therapy, a co-parenting counselor, um, a parenting coordinator, a support group, it's not a sign of weakness. It's a sign that you understand what you're carrying and that you're taking seriously your responsibility to show up for your child. If your child is struggling, if you're seeing behavioral changes, withdrawal, anxiety, please don't wait. A child therapist who specializes in family restructuring or reunification can be incredibly valuable to the family, and you don't have to be in crisis to start that conversation. Let's talk for a minute about high conflict situations. I just want to take a minute to acknowledge that not all co-parenting situations look the same. I know this. I see them daily. Some parents, many parents, can work through the disagreements without a lot of court involvement. They communicate reasonably, they're flexible when they need to be, and keep their focus on their kids even when it really irritates them or it's hard or inconvenient. And then there are genuinely high conflict situations. These are situations that involve domestic violence, substance abuse, a co-parent with an untreated mental health issue, or simply a co-parent who refuses to follow the parenting plan, no matter how reasonable you are. If that's your situation, the strategies I've described here, they still apply, but the way you implement them looks different. And the legal tools that are available to you are different. Restrictive communication provisions, supervised exchange locations, safety protocols written into the parenting plan, and in serious cases, a petition to modify timesharing based on a substantial change in circumstances. For high conflict parents that know about the conflict and the dynamic of conflict at the time that their parenting plan is being developed, can request either in a settlement conference or through the court to have the ability to come to the court by motion and without having to show a substantial change in order to make a modification. Courts very seldom will award that in an order, but if you're negotiating a parenting plan, that is something you can consider. Special provisions to accommodate the high conflict nature. The key is to work with someone who can help you assess your specific situation clearly, who understands the difference between a difficult co-parent and a genuinely unsafe one, and who can help you pursue the correct remedy. Sometimes that's a lawyer, sometimes it's a counselor, sometimes it's a parenting coordinator, sometimes it's a psychiatrist or a medical doctor. Use your resources. Co-parenting is hard. There's no way around that. But it is also one of the most important things you will do for your child. And getting the legal framework right from the beginning makes everything more manageable. The parenting plan and the development of the parenting plan makes all the difference. If you have questions about your parenting plan, your rights, or how to handle a co-parenting situation that isn't working, Road and Law is here to help you. Our consultations are always complimentary, and you can reach us through our website, and we'd be glad to talk you through it. Thanks for watching. Take care of yourselves, and take care of those kids.